Greetings and welcome to Motions, Papers and Additions Thereto from American Jurisprudence. If anyone got the notification, please let me know in the chat. It seems like notifications didn't go out. Get confirmation and we'll get it going and we'll edit this part out. Excellent. Okay, so then we have confirmation. Let's get going. Okay, so we'll be going over the second part of motions, which in regards to the papers and additions thereto. But before we begin, just to remind everyone that this video is strictly for the entertainment, educational purposes of this YouTube broadcast and channel, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. So we're on to the motions, papers and additions thereto from American Jurisprudence. And there we go. So we're going to be going over just a few sections tonight, but they're rather dense. So we're going to go over section 21, which is title, label, or caption. Section 22, which is the notice of motion, which is distinct from the motion itself. Then over the supporting affidavits, memorandum of points and authorities, and exhibits. And then we'll go over the timing for the filing of affidavits. And finally, the papers in addition to original motion papers, and the reply affidavit, finally, for the main event. Let's get going. So, Section 21, the title, label, or caption. A court determines the nature of a motion by its substance and the relief sought. An important label is not fatal. An improper label is not fatal if the motion's purpose is clear and does not prejudice the other party. So key in the way it's the motion's request, and I guess the relief sought and its substance does not prejudice the other party. So that's key part right there. Let's continue on. The moving party generally has the burden of correctly labeling its motion. So when you're the one writing the motion, the moving party, you have the burden of correctly labeling it. The nature of a motion is determined by its essence, substance, or the relief sought. So in that wherefore section and the essence and substance, what substance there is in their substantial regards for that motion is the nature. A court is not bound by a party's characterization of a motion. So if one party says, it seems to me it's this kind of emotion or that, the court is not bound by a party's characterization, including the moving party. An improper caption may not be fatal where the nature of the motion can be ascertained from its substance, so then the improper caption will not fail the motion or have it denied. The body of the motion complies with procedural requirements, so everything else is in check except for the caption. And the incorrect label does not prejudice the non-moving party. So again, any kind of trickery in that label or the caption that intended to prejudice the non-moving party, then that would be fatal. Let's continue. Boy, it's taking one. There we go. All right, so section 22, the notice of motion, part 1. The notice of motion must clearly state the relief sought and may need to specify the grounds, depending on the jurisdiction. So a notice of motion. Sufficient notice is critical to prevent a void order. So a notice of motion must state the relief sought. It may state when and where the motion will be made and the papers on which it will be based. The notice must generally define the issues to be raised, generally. And some jurisdictions require the grounds to be stated with particularity on the notice. Wow. So notice of filing is usually just generally defining the issues. If a party does not receive notice and an order is entered, the order may be considered void. So it's not even voidable, it will be void. Relief may be granted despite a technical error if the notice is explicit enough to prevent mistake. So either way, despite technical errors. But that's when the notice is explicit enough to prevent a mistake. So a lot of burden there. And we're on to the notice of motion, part 2. Federal rules demand specificity, and while supporting papers can clarify an omission, the notice itself must be precise, as it may not be enlarged by other documents. So here's our observation. Under the applicable federal rule of civil procedure, a motion must state with particularity the grounds therefor, and must set forth the relief or order sought. Similarly, the applicable federal rules of criminal procedure provide that a motion must state the grounds on which it is based and the relief or order sought. So the motion must state the grounds on which it is based and the relief or order sought for the criminal, and with the civil, set forth, particularity. Okay, so civil needs particularity is a big difference here. Similarly, finds a motion shall state the grounds on which is based. So perhaps maybe there's a little bit more particularity required in civil procedure, but would have to look more closely at that. Other than that, the practice tip here is an omission in a notice of motion may be overlooked if the supporting papers make clear the grounds for the relief sought. Thus, a notice of motion is generally sufficient if the motion and attached documents are sufficiently precise to advise the adversary and the court of the issue involved. However, there is some authority to the effect that a notice of motion may not be enlarged by either supporting affidavits or oral argument. So some authority. So these are things where, I guess, depending on the jurisdiction in the venue, to consider whether you can enlarge the motion outside of the notice that you give to the other party and to the court. So we have supporting affidavits, the memorandum of points and authorities, exhibits, part 1. Affidavits are a primary tool to verify facts and place evidence before the court. Any person can make an affidavit, and it is considered competent evidence unless properly challenged. An affidavit or a written statement may be used to verify the facts on which a motion is grounded. Federal rules of criminal procedure state that a motion may be supported by affidavits. Any person is qualified to make an affidavit in support of a motion. And an affiance declaration is competent evidence unless an objection is raised. Example given is lack of personal knowledge, or a motion to strike is made. So the declaration, the affiance declaration, when filing the affidavit, is going to be competent evidence unless an objection is raised or a motion to strike is made. And here's the example given for an objection: lack of personal knowledge. Very common, you'll find in poorly written affidavits. Here we go, section 23, supporting affidavits, memorandum of points and authorities, exhibits, part 2. Some courts have the discretion to accept late filed affidavits, but they are not required to do so. Do not assume a late filing will be accepted. And our practice tip. In some jurisdictions, a trial court may, in its discretion, accept affidavits supporting a motion, even if the affidavits are submitted after the motion is filed. However, while the trial court is vested with discretion to consider the affidavits not timely filed regarding a motion, the refusal to exercise that discretion is not an error. So, if the trial court decides with their discretion whether or not to consider the affidavits, the refusal to exercise that discretion is not an error either. So, discretion to not have discretion. Let's proceed. And we get to part 3 of supporting affidavits, memorandum of points and authorities and exhibits. A memorandum of points and authorities argues the legal basis for a motion, while exhibits are for the court's consideration but are not evidence themselves. So whereas the affidavit is evidence, or can be evidence if it stands unrebutted, the memorandum of points argues a legal basis, and the exhibits are for the court's consideration but are not evidence themselves, just because they're entered as exhibits. Our key points here is a moving party may file a memorandum of points and authorities indicating the law and its application to the facts. Failure to file such a memorandum does not necessarily preclude the judge from ruling on the motion. So this is a nice little thing here, a memorandum of points and authorities, or memorandums of law I've seen filed too. Observation here. Documents which are made exhibits to motions are properly before the court for its consideration. However, documents attached as exhibits to a motion are not evidence, so they're for the court's consideration, but they are not evidence. And we're on to part 4 for the supporting affidavits, memorandum of points and authorities and exhibits. The moving party has a fundamental duty to provide adequate factual and legal support in their papers to put the opposition and the court on clear notice of the issues. And here's our supplement case. A moving party must provide adequate factual and legal support for their positions in their moving papers in order to put opposing parties and the court on notice of the issues to be decided. And that one comes from, let's see here, M3 Healthcare Solutions versus Family Practice Associates PA, and that's in Delaware, 2010. And we have a comment here from Facetious Expert. In our foreclosure, I misspelled the positions for defendant, misplaced positions for defendant plaintiff, but labeled each part correctly and was denied. The silly administrative appeal pretty sweet. Yeah, there's issues in here where some errors like that. It's the substance and essence of it, and if it could be made clear from, I think that was one of our first slides here, that might actually apply in that situation. All right, let's proceed. So we see here the moving party must provide adequate factual and legal support for their positions in moving papers in order to put the opposing parties and the court on notice of the issues to be decided. So on notice. The thing is that you would have to put them on notice of the motion within time before a hearing, so they have time to prepare and consider the substance, of course, of that motion. And now we're on to section 25, papers in addition to original motion papers. And here it is, the reply affidavit. A reply affidavit is a tool to respond to new matters raised by the opposition. It's not an opportunity to introduce new arguments in support of the original motion. So, a moving party may be allowed to file additional papers, such as a reply affidavit. A reply affidavit is generally allowed when the respondent's affidavit sets up a new matter. Failure to deny a new matter by affidavit may operate as an admission of its truth. Ooh, boy. So you have here a moving party, maybe, so you file a motion. You may be allowed to file additional papers, such as a reply affidavit. A reply affidavit is allowed when the respondent to the moving party's motion, respondent's affidavit sets up a new matter. So that new matter now, because it came in that respondent's affidavit, if it stands unrebutted, it becomes or is interpreted by the accepted as the court as a fact. So failure to deny a new matter by affidavit may operate as an admission of its truth. The function of a reply affidavit is to answer arguments made in opposition, not to introduce new arguments in support of the motion. So these are arguments made in opposition to the motion and not to introduce new arguments. So let's look at the summary of the key principles that we went over here. We have substance over form. The nature of a motion is determined by its substance, not its title. That was section 21. Notice is critical. A notice must state the relief sought and grounds. Failure to provide notice can be fatal, so you always give notice of your motions in a timely manner. Support your motion. Use affidavits for facts, memoranda for law, and be aware of timing rules and court discretion, sections 23 and 24. And most importantly, replies are for rebuttal. A reply affidavit addresses new points from the opposition. It is not for reinforcing your original case. That's our final section 25, which brings us to the end of our presentation on motions, papers in addition thereto, and which will take us down for the rest of this part of AmJur here with orders, rules, and motions. So we've completed the motions. Next step will be one of the other two. I believe it's orders. So stay tuned and salute you all for being here, and I hope to see you all on the next one. Peace out.